Hello, everybody. Assalamualaikum, Sastika, Namaskar to all the listeners. This is Attorney Shaparali for the Shaparali Law Show, and we're broadcasting live today on Radio Zindagi, KLOK, and it is November 15, 2018. And I have Michael on the board with me. Thank you, Michael, for being here. And, of course, anything I'm going to tell you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And today we're going to talk a little bit, of course, not a little bit, a lot about immigration. We will be opening the lines in a few minutes. The number to the studio, 510-657-1170, 510-657-1170. And if you need a private consultation, the number to our office, 510-742-5887. 510-742-5887. The website to check, attorneyonair.com. We'll start, of course, about the visa bulletin. As you can see, the visa bulletin now, we're going to focus a little bit on the employment side. If you look at the new visa bulletin for December 2018, EB3 India went up, and it's moving. It keeps moving now. It reached January 1st, 2010, while EB2 stay May 2009, which is kind of now getting a lot of people sad. They have moved to EB2, but there are ways to deal with that. For one, if you file a case, you have approved, and you're moving, you filed it, basically started as an EB2, but you have not filed the I-140, you can file the case as an EB3. There are ways to do that. And cases that file an EB2, can you downgrade? It is possible, but you have to amend the I-140 if the I-140 is already approved, which is a little bit more a headache. So, but at the end of the day, we are seeing a lot of improvement in terms of EB3. Then the reason for that is that a lot of people have shifted to EB2 or EB1, and that has left EB3 kind of clear to keep moving. For years, we have never seen EB3 moving that fast like it is moving right now, and many lawyers are believing, and many people are believing that for the next 5-6 years, we're going to see EB3 moving faster. Having said that, we are hoping there will be no retrogression on EB2, and usually EB2 is always the safest route. Now, the question is, what can we predict? Well, we cannot really predict, but so far it's moving at a steady pace. EB1 kind of is, I think EB1 went a little bit backward, if I'm not mistaken. Let me check. No, actually it went forward. It went forward to September 2016 on the first chart, and chart number 2 is different. So I'm talking about chart 2 when it comes to because in the past last month they started using chart 2 to accept application. If you look at chart 1 for India, EB2 is March 2009, and EB2 is April 2009, and EB3 is March 2009. But if you look at chart 2, it is 2010. So there is a chance that EB2 is going to, if they use the chart 2, EB3 is in a better position. So it's a little bit confusing when it comes to those. If you look at it on the chart 1, EB2 is still higher than EB3, but on chart 2, it is different. So that's what a lot of people are confused. What chart 1 is and what chart 2 is. Number 1 is the one that they accept the application. For example, if USCIS kind of take user chart 2 like they have done last month, then what it does, you can file your case and at least get an EAD until the dates become current. But having said that, there is a tendency for EB3 right now to move faster, although it is, in terms of pace, it's going to go faster. Although if you look at the chart itself, number 1, the one where they issue the green card, chart A or chart 1, you will see that it's still EB2 is April 2009 and EB3 March 2009. But if you look at chart B, which is the processing time, acceptance time, it's May 2009 and EB3 January 2010. And if they follow the same thing that they did last month, you will see people will be able to apply for adjustment of status if they're here on EB3 on January, who has a priority date of January 1st, 2010, etc. So it's a little bit, like I said, it's confusing. I myself got trapped on those two charts right now. But bottom line, it seems like there is a movement that is going faster on EB3. Having said that, should you shift to EB3? That's the million-dollar question that is very hard to answer at this point, but many people are believing that EB3 will move faster. So again, ladies and gentlemen, we will be opening the lines at 510-657-1170. If you have any questions on immigration, feel free to call the studio, and we will, if we can answer, I'll be glad to answer it for you. So we were talking about the visa bulletin, and the visa bulletin has been a nightmare for India for years. We see jump up and down and many other issues that are related to that actually we have age out children, etc., etc. So hopefully we are going to see some change in that, but so far we have not seen anything really great, except we have seen a movement under EB3. So now let's just talk a little bit about other issues that we are seeing right now. H-1Bs are, of course, a lot of people now are getting their answers on the H-1B, especially for people who have done new H-1Bs. We are seeing some good approvals, but we're also seeing some denials. And many of the denials are related to two main points. One, the specialty occupation, and number two, employer-employee relationship, especially if you're working for a consulting company or a placement company. It's becoming a case-by-case issue, although we are seeing a trend that in certain professions, they are basically almost kind of bending backward to give a denial. So you need to be ready for that. Next year, many professions might be out of the list of the ONET book, which means the H-1B will not be available for those people. So it's the question is that what happens next? Well, people should, for students especially who are here and who have filed an H-1B and who have gotten in the lottery but who have gotten a denial, what can they do next? A lot of them ask that question. Well, one of the options they can take, of course, is to, if their OPT is still good or they are on OPT, for example, they can continue, or if they are on F1, they can continue, or they can, of course, continue, go back to school. But this is where it gets tricky. A lot of people tend to go on the CPT, and it's not a good idea to really take CPT like that. Be very careful on that, especially if you're in the same level of education and you go and get another, for example, you are in a master's degree, you go and get a second master's and you try to take CPT on day one, etc. It is not recommended because there are rules against that, and they will use it against you down the road when you file for an H-1B. We mentioned that before, but I wanted to mention that again because now we are getting many of those calls. So, ladies and gentlemen, if you have any questions, of course, the number to the studio, 510-657-1170, 510-657-1170. And many things, of course, are happening. I think we have one caller. Let me take the caller, and then we'll continue on that. This is Shabra. Hello?
Hello?
Hello? Yes.
Hey, good morning, Shafar. This is Shiva.
Hi, Shiva. How are you?
Good. How are you? I have a quick question on the EB1. EB1 is retrograded to 2012. Now I think it's 2016. Is there any news about that they are going to make it current?
I don't think it will get current soon. That's a question a lot of people are asking me. But I think it's going to go forward. It won't get retrogressed. That's the good thing. But we might see a movement probably around April, bringing it to very close to current. But current completely, I doubt will happen unless we are very lucky. But it's going to be a tough one. But people should still file their EB1. Getting current completely, maybe if it happens, it will be next October, next fiscal year. Okay?
Okay.
Okay. Good luck. And,
okay, thank you.
Any other questions? You're welcome. So I was talking about H-1B, but there are also other issues. And again, if you have any calls on it doesn't have to be on employment based, by the way. You can call on anything immigration where I can answer. I'll be glad to answer. 510-657-1170. 510-657-1170. And I hope, Michael, I have it. I'm saying it right, the number. So I'm talking now about what I didn't start it yet, but there is one thing now that is coming from the USCIS, which is basically the asylum. As you know, they are planning to amend the asylum in the next 90 days. They have already kind of put this out there that for those people who entered unlawfully, entered illegally and entered the United States or tried to enter, they will not be eligible for asylum. They can be eligible for withholding, which is different, or a Convention Against Torture claims, but not really asylum, which is very different because, number one, withholding doesn't give you a lot of things. And number two, the Convention Against Torture is a higher standard to prove. So based on that, it's going to become more and more difficult to file those cases. However, this might not really go through because you have probably it's really in contrary to the intent of the legislation. If you look at the legislation itself, and it's been like that for 40 years. So let me take another call and we'll talk a little bit more about that. This is Shapra, you're 11 here. Hello? 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 Michael? Hello? Is this right? Hello?
Yeah, hi. Can you hear me?
Hi. Yes, Raj, I can hear you. Go ahead.
Yeah, okay. Thank you for taking my call. I have a quick question. A green card holder, can he or she extend their travel document outside the country, from outside the country?
No, unfortunately. It used to be the case, but right now they are not allowing it. I've heard one exception in one case because a person got sick, but then you don't really need that when you're sick. So, no, usually you have to be here, at least file it, do the fingerprint, and then you can leave.
Well, for the fingerprint, minimum fingerprint here, huh?
You have to do the fingerprint in the U.S.
Yeah, and once fingerprint is done, then you can leave, huh?
You can leave, yeah. But just make sure it gets approved. If it doesn't get approved, you will have to come back beforehand because you never know if it might get denied. It's very rare it gets denied, by the way, but you need to be ready for that. Okay?
Yeah, and generally they take about, 90 days to let us know?
A little bit more.
A little bit more these days,
maybe 4 or 5 months sometimes.
4 or 5 months, Okay. That's all I had. Thank you for taking my call. Appreciate it. Good program.
No problem. Good luck to you.
Thank you, sir. Bye-bye. Take care.
This is a very good, interesting question. Let me take another. This is Shapra. You're live now.
Yes, good morning. I just wanted to ask regarding the visit visa application. So, is there any right time or like some people were telling this is not the right time for the visit visa because that might get denied and stuff like that. So, do you have some comments on that?
Some insight. Well, definitely, this is not the right time for any visa. It's not only the visitor visa. But at the end of the day...
Actually, your voice is very low.
Can you hear me now? Can you hear me?
Yeah, a little better. Yeah.
Okay, sorry for that. Well, this is not the right time for any visa right now, unfortunately.
Okay.
But people are still getting their visitor visa. As long as you can convince the officer you will come back, and that's pretty much at their discretion and who's the officer doing the interview, and you don't have any kind of other issues on your file, like for example you overstayed, you have a criminal record, etc. people are still getting it. Elderly people are getting it. People from certain countries, of course, are still getting it. But even for India, a lot of people are still getting it. I have a video on applying for the visitor visa on my YouTube channel, youtube.com/Shahperalilaw, SHAHPEERALLYLAW. Check it, and you will see it kind of guides you. It's the same thing. I did that long time ago, but nothing has really changed, except now they are many times they're giving shorter at the airport in terms of the I-94, but the rest is pretty much the same, but definitely they're a little bit more strict.
Can you repeat the last one, Shah? I couldn't hear you. What about I-94 you said?
Is that, yeah, the rules are still the same on the visitor visa. They have not changed it, but they're a little bit more strict, that's all.
Okay. And one follow-up question on that is it good to sponsor from here, or is it good for the person to be self-sponsored?
Well, the truth is that when it comes to visitor visa, you're not really sponsoring. You can put an affidavit of support.
Your voice is again. I'm
sorry. Can you hear me? Right. I say the truth is that there's no real sponsor for the tourist. Putting is an affidavit of support. So, bottom line, it's always better if you have your means to pay for your visit. But if you don't, and you have, like, for example, a son, a daughter here, they can put the affidavit of support. Hello?
I couldn't hear you, Shah.
Okay.
There's some disturbance
hang up.
actually.
Let me give you the answer offline. Okay, go ahead.
Okay, so let me go to the radio.
Okay. So basically, the question is it better? The question that he just asked is it better to have your visitor visa be sponsored? I mean, basically, the affidavit of support is from someone from the U.S. or coming on your own money. Of course, if you have your means to pay for your own bills, it's always good to show that, because that shows the money is coming from outside, and it shows that you have an intent to go back if you have enough means out there. However, it doesn't really make a difference if, for example, your son or your daughter is putting the affidavit of support. So it's unfortunately there's no clear answer on that. But it is always good to show that you're using your own money to basically come here. So let me take another caller, Michael. Hello? This is Shah.
Hello?
Yes, sir. Can
Hello?
you hear me? Yeah.
Hi, can you hear me?
Yes, I can hear you very clear.
All right, thank you. My name is Mayur. I am on L1A visa. I have a question regarding the GC filing. My employer is filing my GC in EB1C category, but my attorney is asking a question whether if we should file it in I-140. We should file I-140 right now, or wait for priority date to become current and do a concurrent filing with I-140 and I-485 together. So I wanted to know which option is good, and also wanted to check if we file I-140 first, and if we file can we file the I-485 once priority date becomes current, or should we wait until, or it is required to wait until I-140 approval?
Okay, two very good questions. Number one, don't wait, okay? Companies always try to do that to hold on people. So don't wait, because if you file it now, you lock your priority date. And since EB1C, there's no premium on it. It takes around 1 year, 1.5 years sometimes. It's better to file it as soon as it is ready. Okay, so don't delay on it and wait for I-45. All this doesn't. For me personally, I think this is not right. Now the second question: do you have to wait for the approval to file the I-45 while the case is pending? The answer is no. You can use the same receipt of the I-140 and put your adjustment of status attached to that if the dates become current.
Oh, okay, great. So we don't have to wait for I-140 approval as such.
No, you don't have to. But I will highly recommend, if you're eligible for the EB1C at this point, go ahead and file it. Don't wait, because if you wait, you lose that priority date time. Plus, you don't know if it will get current, and what happens if it gets delayed. And plus, if you have the I-45 file down the road, the dates become, at least the processing dates become current. You might be eligible for AC-21 and transfer. And that's one of the reasons companies don't want to file, because as long as you're an H-1B, you're pretty much at their mercy, right? Kind of. So
right.
If you get a chance to file the EB1C, don't wait, okay? Go ahead for it, okay?
Okay, thank you so much.
You're welcome. So I don't know who called us, Michael, but thank you so much, all of you guys calling, and this is what really kind of makes our day. And also, I wanted to congratulate our team for a bunch of approvals recently. Three difficult RFEs we dealt with for people who shifted, companies who shifted with us, and we got the approval. So I wanted to say congratulations to the team. And also, we got a bunch of EB1 for our Washington, D.C. team, Sharif, Kainat, and entire people working there. They are doing an excellent job on EB1. And I wanted to congratulate them. And a couple of U visas also got approved. So bottom line, it's not like we are getting denial. In fact, I have not seen a denial for a while in the past few weeks, and that makes me happy. But that doesn't mean cases are easier than before. Definitely, we are expecting denials, because that is a no-brainer. But if things are done properly, and if you have basically all the ingredients, you're still getting approvals no matter what. And now, of course, we have this asylum thing, ban for asylum, which is luckily for our community, most people don't come this way, but I know for our communities it's kind of tough, because many of those people, they come really fleeing from war countries like Nicaragua, Colombia, etc. So our heart goes to them at the same time. Now, the other thing that happened, of course, the election last week, and we didn't have a chance to talk about. Well, I think we didn't have a chance really to talk about it, but it's going to have an impact on the immigration. I'm hoping that it's going to have a positive impact, because it seems that the Democrats are really going to fight to keep immigration intact, although the administration will fight back. So let's see how much influence this is going to have. I also seen a couple of letters from big companies basically complaining that they are getting difficulties in the H-1B. That might also help the whole momentum. And there are a bunch of lawsuits going on. So it seems the momentum is turning back to the favor of immigrants. But having said that, until we get really some results, we can only kind of hang on and do things the way we can at least protect the people as much as we can. And said that, I wanted to congratulate our team. It's been like now 13 years I opened the law firm. Well, I've been a lawyer before that, but we opened the law firm 13 years ago, and since then it has been quite a success for everybody. And I'm very, very proud of the team. We had a lot of people who came on board, and some of them became famous lawyers when they left us, of course. And I wanted to thank them too, because no matter what, they have actually kind of contributed to the success of this law firm. It's not a one-man show. We have a lot of people that work with me, and I can name all of them: Shabana, Lubna, Mamuna, Lashalini, all those people who have worked with us. And we have also Sharif we have Kayanat, we have Darshi, we have Aditi, we have you name it. We have a very, very team. And also in our San Francisco office, Jimmy, Sami, Ishaida. So we are not kind of a one-man show, like I said. So oftentimes you will see me telling you, okay, this is you will be referred to this and that, because the fact that what we do, we oversee the work in a way that we pick those who are best at one thing, and so we make them focus on that, so that we can give the best of ourselves. And lately, of course, we have been facing a lot of difficulties with the changes in law. But having said that, we are still able to overcome many of them. So let me take out a caller, Michael, and we'll talk about it. This is Sharp Raleigh, you're 11 air. Hello.
Hi, good morning, Shah. Can you hear me? Because you're coming through very garbled.
I can hear you. Oh, I'm sorry, but I can hear you very well.
Okay, great. So let me ask my question, and I can take the answer offline.
Perfect. Okay.
So my question is on the National Interest Waiver, NIW. So I am considering, I am in like the healthcare space, and I'm considering, getting a National Interest Waiver. I have a couple of questions. First, can I port my priority date? I'm currently on EB2, and I have a priority date. Can I port the priority date over? And second question is, if I decide to, let's say, leave the U.S. for a few years, will this NIW-based I-140, still be alive? And can I apply for an I-485 from outside the U.S. based on it? So I'll take both the questions, or both the answers offline. Thank you very much.
Okay, you're welcome. So number one, yes. Okay, I'll wait for you to get on the radio. But number one, yes, of course you can port the priority date. But remember, Interest Waiver is also EB2, so definitely you can port it. Number two, if you leave the U.S. with an approved I-140, does the I-140 go? The answer is no, unless USCIS revokes it. And number three, can you file I-45 from outside? No, I-45 not filed from outside. However, you can still process the case to the National Visa Center and come back here to straighten your green card. In fact, I've done many cases where people have never come here. We filed directly the green card and the National Interest Waiver and brought them here. So it's, I hope I was to answer the three questions. Number one, yes, you can port the priority date. Number two, even if you leave, the I-140 is still alive, as long as USCIS doesn't take it away through revocation. And number three, I-45 cannot be filed from outside. You can still transfer the case, and it's the same it's kind of the same process as the I-45, except it's done to the Council of Processing, then it's done to the National Visa Center, etc., etc. So I hope I answered all your questions there, and if you missed anything, please give us a call, 50-742-5887, and also you can call the studio line today, 510-657 1170, 10-657-1170. And also we are talking, of course, about immigration here. This is Attorney Sharp Raleigh. We're live on air, and today is November 15th, 2018. And as I was mentioning, this month our law firm celebrated its 13 years of existence. And since then we had some great people working with us, and we had some great cases, some great success rate. And I tried to count how many cases in just cases I've done, and I think we have reached thousands, and of course consultations is the law. So I want to thank all the people who have supported us and who trust us to continue trusting us. Hopefully we should be able to continue, God willing, of course, and continue helping the community. And the way immigration law works, it's a lot of passion you put into it. Unfortunately, it's not something you can just learn by reading books. I've practiced other areas of law. You can pretty much, for example, contract law, you can just get a bunch of books and read it, and you will be able to practice contract law. The same for many other areas of law, transactional law, for example, wills and trusts, etc., etc. Of course, you have your experience that comes with it, but it's something that you can practice easily. But when it comes to immigration law, this requires a lot of concentration and knowing pretty much a lot of law, because you have to combine a bunch of law sometimes in one case. For example, someone who overstayed and someone who went illegally and someone, if one mistake, that person can end up getting deported, or that person can get stuck outside. And having said that, nobody knows it all, but the basics have to be there, the foundation has to be there, and that's where we have been able to differentiate ourselves, and our team has been able to differentiate itself. And I'm proud of this team, and everybody who has worked with us, pretty much we have been able to work our way, luckily, and the way of our clients. So I wanted to thank them all from the bottom of my heart, and thank everybody for supporting us on all those endeavors, right? So also our radio show is reaching its 9th year, I think next year, and without your support and without people right now kind of continuing listening, we would have been kind of talking in what we call thin air. I want to all in the game, Michael, the whole team there, who always kind of try their best to make things easy for us, and for that I'm very grateful too. And now, of course, we are talking about immigration law, and the lines are still open, I think, for a few minutes, or another 10 minutes, I think, right, Michael? 510-657-1170, 510-657-1170. One of the questions that I'm getting, a lot of people, because of the situation of denials, they have to go back and get their visa and come back, etc. They're asking me, should they sell their houses? Should they sell their properties? The answer is it's up to you. You don't have to. Just because you lose your status doesn't mean you lose your properties in most states, because most of the, I cannot pronounce for other states because that becomes state law, but for California, even if you lose your status, you don't lose your property. You still own it. You can still kind of delegate it to a power of attorney to actually kind of sell the property or manage it for you, company, etc., manage it for you. So you don't have just to sell like that, because there's a big chance you will be able to come back down the road. Now, if you want to sell, etc., just make sure you just don't go into a panic mode and just start selling at a panicky mode, okay? And of course, one of the things that brings me to our next topic, which is debt settlement. A lot of people who are leaving also, not only people are leaving, some people are struggling, so they have debts on their credit cards, or they have other kinds of debts where we can kind of negotiate those debts to bring it to a lower value. We can help you on that. And the number to call for that is 510-742-5887, and we call it debt settlement. So the website or the blog is yourdebtsettlementattorney.com, yourdebtsettlementattorney.com. We have been able to do that for years now. I think we're going on the 10th year doing that. And we have been able to save a lot of people, including their second mortgages, their credit card bills, even lawsuits against them. We have been able to negotiate. The way it works when it comes to debt settlement is negotiation, nothing else. It's what we call pre-litigation stuff. So basically, we know the case is going on a litigation, so it has not even reached there. Or even if it is there, we might be able to negotiate with the other side. Either it's a collection agency, the credit card company, or ultimately if there's a lawsuit, etc. So we can kind of negotiate with the other lawyer and bring it to a fraction of its value. For example, someone who's $100,000 in credit cards, we might be able to bring it to $20,000. And again, this is just an example. But just because I'm giving those figures doesn't mean we get that. It's just to illustrate what I'm saying here. So be careful on that. And when it comes to debt settlement, only debt settlement, of course, we actually give you, we don't get paid until the case is finalized and we get a deal for you. So you can try it. Give us a call, 510-742-5887. The blog to check, yourdebtsettlementattorney.com, yourdebtsettlementattorney.com. And Michael is indicating to me that I have a few more minutes left, so if you have any callers, Michael, let me know. 510-657-1170, 510-657-1170, the number to the studio today. And we are live. It's November 15, 2018. I keep giving the dates on purpose because sometimes it does happen that I'm busy, I cannot do the show, so they repeat the show. So in those cases, that's why one of the reasons I actually are giving those dates. And also probably next month, by the end of this month, I might be traveling a little bit, so some of the shows will be actually recorded shows. So bear with us. And of course, you can always call our office, 510-742-5887. The website, attorneyonair.com, attorneyonair.com. So, as I mentioned at the earlier stage, Visa Bulletin 2018 seems we are seeing EB3 on the acceptance date is overpassing EB2, and it's getting close on the regular chart. Also, it's getting close to EB2 and probably will surpass EB2 soon. And a lot of lawyers, including myself, think, and we might be wrong, by the way, that EB3 will move faster in the next 4 or 5 years, and that's kind of the prediction of the day. And for those, but remember, you cannot shifting to EB3 has its own issues. It needs to be done properly. If you have a labor certification that was approved, it was filed under EB2, but now you're going to file as an I-140, you can always file under EB3. If the I-140 has already been approved, then you have a problem. In order to move to EB3, you might have to get an amendment of the I-140. And the truth is that reducing it downward is a little bit tricky. I have not personally done any of them, so I cannot really tell you what is the success on that. But it is there, it's possible, but there are some complications to that. Now, going back to the other topic that a lot of people are talking about. Oh, one topic that I omitted, the NTA memo. The famous NTA memo is going to be implemented on the November 20th, which means basically if a case is denied now, they can send it directly to what we call a deportation. And NTA is a notice to appear. That means you go in front of a judge. They say this will not apply to EB, employment-based cases, which is a good thing, especially for H-1B. But they will apply it for student visa. They will apply it for family petitions, for VAWA, etc., etc. So be on your guard. They say they will give at least kind of a notice, I think, of 30 days, but I have not really understood that clearly to kind of confirm with you. But we'll have to let the thing roll and let's see what happens next. But bottom line, excuse me, bottom line, you have to be ready that things are going to get tough out there. Although we are seeing certain relaxed rules on one side, it's still going to be tough on the other side. So if you need help on any of those or you want a second opinion, feel free to reach out to our office, 510-742-5887. And this is kind of the third announcement. I was omitting it earlier. And, of course, the other second one that I mentioned earlier was this asylum that is changing now. And we don't know how this is going to unfold because I'm pretty sure there will be a bunch of lawsuits on that because it's kind of contrary to the legislative intent and the executive order and that President Trump passed is it might not really hold in court, but let's see how things are going to work out. But bottom line is going to have a chilling effect on many people who file for asylum, especially if they entered EWI. EWI we don't use anymore, but it's entry without inspection, etc. So be ready for that. However, people will still be eligible to file for withholding, which pretty much keeps you in the country until situation changes in your home country, or a convention against torture, where you basically have to prove extreme kind of hardship in order to not go back. So all this stuff are happening as we speak, and they say the NTA memo, the famous NTA memo that everybody were worried about, is going to get effective as from November 20th. So that means in 5 days. Certain cases, as soon as you will see a denial, you might get an NTA ASAP. So one of the solutions, if you have few days and the case can be refiled, make sure you file quickly. And this will probably apply for family petitions, VAWA, and also student visas. So be careful. Sometimes for students, especially, their service get terminated and they don't even know about it. So make sure you are checking with your DSO, the designated school official, about your status once in a while, just to make sure that there's no problem on your status, because sometimes there are mistakes, there are glitches on the system of service, etc., and that can trigger a lot of problems. The other problem that we are seeing, if you combine the memo of the NTA with no RFEs, then suddenly you might see someone getting a denial and quickly be placed in deportation. So all those factors are going to factor in, and we need to be ready for that. So while we have already kind of surfed a number of waves that has come from the administration, this one is going to be a new dimension, because it's really put the person into deportation without really kind of giving a chance to respond or something else. So you need. We have another caller, Michael, or is it Amit?
Hey, Shah, this is Amit.
Hi, Amit. Give me 2 more minutes, Amit.
Sure.
And then I'll let you take over. So, yes, ladies and gentlemen. So to recap today, 3 announcements. Number 1, the visa bulletin. It seems EB3 might be doing better for India than EB2. And the second announcement we have is basically the situation for asylum seekers. Some people who entered illegally might not be eligible to file for asylum, so which is something that we're waiting and seeing. But they say they are proposing the rule and to be effective in 90 days, etc. And the third thing we were talking about, which is basically the situation where the NTA, this is the NTA, it is to appear when people are placed in deportation. A good thing is that it doesn't apply to EB categories, that means employment-based, but it's going to get effective as from November 20th. So we are going to see a government kind of starting doing that. And they say they will give a warning, but let's see how things unfold. So, ladies and gentlemen, if you need help on any of those, either it's immigration or debt settlement, feel free to reach our office, 510-742-5887. The website is attorneyonair.com, attorneyonair.com. Thank you, Michael, and anything I told you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any question. Thank you, and again, we have a YouTube channel. Please subscribe to it, youtube.com/sharp-raleigh-law. I try to put updates on it on a weekly or bi-weekly, so please check it. And I'll have Amit take over from here. Amit, are you